On Friday refused to grant the detained leader of the proscribed indigenous people of Biafra, Kanu, freedom. Kanu, who was first arraigned on December 23, 2015 and later granted bail on April 25, 2017, had in his appeal dated April 29 applied to be discharged and acquitted. Ruling on his appeal, the Abuja Division of the Appeal Court declared as illegal and unlawful his abduction from Kenya to Nigeria and quashed the entire terrorism charges brought against him by the federal government. The court held that the federal government breached all local and international laws in the forceful rendition of Kanu to Nigeria, thereby making the terrorism charges against him incompetent and unlawful. Justice Emmanuel Ajim of the Supreme Court, however, in his judgment, held that the illegality committed against Kanu cannot exonerate him from being tried, though he condemned the invasion of his home after he had been granted bail, saying this does not portray the country well before the international community. Going further, Justice Ajim added that there is no legislation that divests a court from its jurisdiction in trying an accused person before the court, despite the level of inhuman treatment meted to him by the security agencies since suspicion has been established. He then granted the appeal filed by the federal government, which challenged the freedom granted to Nnamdi Kanu.
As you have all observed what happened today at the Supreme Court, if you ask me, I would say this is victory to administration of criminal justice, because it shows that once you are an accused person, once you are a defendant, no matter what excuse you want to bring to hide under the law to say that you should not be tried,
court says represents the law. We respect it. We go by it. There is no other way. We had hoped that it would come our way, but it has gone the other way. It simply means that we have to go back to the High Court and get done with this quickly. We still have hope. We're not in despair.